address the concerns of how impactful the Chevron decision is, again, it's just overturning this doctrine that says federal judges are required to defer to whatever that rule was in certain instances, when there's a conflict or when there's an ambiguity. It doesn't totally take away the rulemaking authority from executive agencies. It doesn't restructure the executive branches at all, but it does limit how the court system plays out a case when somebody brings a suit and there's an ambiguity that the federal agency has taken the liberty to issue a rule on.
The Supreme Court issued a decision in a case that, overturned a doctrine called Chevron Deference. And the long and short of it is, not to get bogged down in technical details, but who ultimately governs our society? Do you do this Chevron deference, which says, well, it doesn't really matter if you're actually right on the law. We are going to defer to what these experts in the bureaucracy think the law means or the regulation should mean. These are people that are not elected. These are people that are, quite frankly, wrong about a lot of things.
That's Governor Ron DeSantis, the great state of Florida, talking about some of the fallout from the Chevron case, Chevron being overruled by a combination of cases before the Supreme Court. Chris, I know that, when we start talking about administrative law and rules and regulations, people may get a little bored, their eyes may glaze over, but that kind of stuff is what affects how we literally get by every single day when we deal with small businesses, which are, 80, 90% of America's economy.
Yeah, and I'm glad that we've had some important SCOTUS cases, one of which we talked about, where there's no statute of limitations on some of these suits that businesses can file, which is very important. Tim, before we get to our next guest, I want to apologize also a little bit. One of my favorite movies back in the day, New Jack City, one of the main characters was Nino Brown. So if I mistakenly call Mr. Marchese Nino Brown, apologize for that in advance.
Yeah, he might feel off.
Love New Jack City. That was my movie.
Let's bring in our next guest. He is the aforementioned Nino Marchese. He is ALEC's Criminal and Civil Justice Task Force Director. A little bit about Nino. He's got an incredible pedigree. Chris, he came from the office of U.S. Congressman Thomas Massie.
All right.
Where he served as the director of the Congressional Second Amendment Caucus, so we can ask him some 2A questions as well. He's now at ALEC. He is working on all things civil and criminal jurisprudence-wise. And he also happens to be a law student right now, going to be graduating soon from Indiana University School of Law. Nino, thanks so much for joining us here on the program.
Thank you, Tim, for having me. And I take the title Nino Brown with full honor. My blue G money suits with great pride as well.
There you go.
I love it. That is fantastic.
Wesley Snipes was the lead character in New Jack City.
That's very good. It's very good. So Nino, we've been speaking about Chevron for quite a while. I, as a recovering attorney, still duly licensed in New York and the great state of Missouri. I follow the law. I've always been fascinated by it. I made it my career for over 2 decades before I transitioned more into media and government affairs work. But Chevron is something I've been closely following ever since Justice Gorsuch was confirmed, because I remember getting distracted by the television during those confirmation hearings, and I sat down and I watched them grilling Gorsuch on basically his attacks on the Chevron Doctrine as a lower court federal district court judge, his proper attacks. This is something that Gorsuch has had his eyeballs on for a long time, and he finally got to write the opinion he's probably wanted to write his whole career, right, Nino?
Yes, that's correct.
And tell us a little bit about the Chevron Doctrine, and why has it been around for so many decades unchallenged, and how much damage has it done through the administrative state?
Sure, absolutely. So, and like you, share passion for law. My eyes too glaze over when I start reading some agency rules and regulatory reform stuff. But I think for your viewers and your listeners, we can break this down in simple terms for them to understand why it's so important and what was so wrong and why this overturning of Chevron was such a victory. The Chevron Doctrine, Chevron versus Natural Resources Defense Council case, it's been around for the last 40 years. And when the court originally made the decision, it was done in a seemingly genuine effort to help expedite the implementation of laws so that they're enforced more efficiently. They really didn't see it like they were doing some, extending some power to the executive branch, and they didn't really foresee, what we've seen today. For those not familiar, what the doctrine does is it mandates that all federal courts, when there is a question of law that is ambiguous, a federal statute rather, a gray area, it's not clearly defined, and then when a federal agency, a separate branch of government, the executive branch, then takes their liberty of rulemaking to kind of extend beyond in that gray area and define terms themselves. The court, when faced with a case where that's the subject of the case, they have to automatically, by judicial opinion, binding decision, take that approach. And so what that really does is it kind of gives the one party in that lawsuit a huge leg up in the justice system. I think when people, if somebody's harmed by an executive agency rule, so much so that they're passionate enough, they have the wherewithal, the financial resources to actually bring a lawsuit against the federal government to find some recourse and some, gather some damages or injunctive relief, whatever it is. You say, okay, well, they're going to court, they have a real case, a solid attorney, let the justice system do its thing. But it's not a fair game. The game's kind of rigged from the start because the court is already, by Supreme Court binding decision, forced to defer to that. And so what that's looked like in the last 40 years is a lot of decisions, particularly in the commerce and business and regulatory space, the environmental space. There's been a lot of EPA challenges, EPA rules being challenged, where courts have had to defer to those decisions at the sake of Americans.
Mm-hmm. One of the criticism that the liberals have lobbed against the Chevron decision is that now a judge is going to have to decide on issues where he is not an expert. Before, he could rely on the administrative state to be the so-called experts to guide him, which that has always seemed a flimsy argument to me, that because during a case, don't each side present expert witnesses and the judge can take that into account to make his decision?
That's exactly right. And further, that's the entire point of the court. Tim, you know this, you're an attorney. When there's a gray area in the law, which is frequent, I mean, we're talking about the law. It's not math or 1 + 1 = 2. It's not science. Everything comes together and makes sense chemically. It's the English language. There's ideology at play. There's worldview at play. Not every human experience can be captured in the English language, and especially in the law. And so that inevitably leaves gray areas. And so when somebody suffers an issue from the law, criminal or civil, or there's a disagreement or somebody feels wronged, the whole point is to go to the court and have each side have legal advocates, their attorneys, argue the best arguments they can possibly do for each side. And then the court interprets the law if there's a gray area and then comes down with their ruling. Chevron deference totally destroys that concept and responsibility of the court, because it says those judges had to refer to whatever some unelected bureaucrat decided the law means, even though that is not their responsibility. It's not authorized that they have to do so, yet courts were bound to do that. So you're absolutely right. That's the role of the court. Subject matter experts are a common thing in cases. And judges, we shouldn't be so insulting to judges, especially judges in the federal judiciary, to assume that they can't make well-reasoned determinations on the law, as is their job in the first place. Mm-hmm.
And Nino, of course, the far left has completely freaked out by the dismantling of Chevron, like they freaked out about so many other cases from the Supreme Court this year. And the criticisms I've heard from the left, especially and the justices that dissented from Chevron, are basically that we're gonna be a world run amok now, right, Nino? There's going to be no rules or regulations for anything. The conservatives hate clean air and clean water. Dogs and cats will be lying down together. I mean, it's just going to be the end of the planet, right? Nino, can you dispel those myths? That's not at all true, right? This is a rebalancing, right, of where we should be, and probably going back to making sure that whatever laws were passed, that the original intent of Congress is carried out, not the intent of some bureaucrat, right?
Yes, absolutely. That's correct. And frankly, I would like to see the Chevron decision go a little further, or just regulatory reform go a little further and rolling back that authority that rulemaking bodies have. Because, again, they are not elected lawmakers. They are not politicians elected into office who are held accountable to the laws they make and then can be kicked out of their job if it's a bad law that harms people. These are bureaucrats that don't have that type of vulnerability. And so that's why I think we would all hope to see some further regulatory reform down the road. But to address the concerns of how impactful the Chevron decision is, again, it's just overturning this doctrine that says federal judges are required to defer to whatever that rule was in certain instances, when there's a conflict or when there's an ambiguity. It doesn't totally take away the rulemaking authority from executive agencies. It doesn't restructure the executive branches at all, but it does limit how the court system plays out a case when somebody brings a suit and there's an ambiguity that the federal agency has taken the liberty to issue a rule on.
You know, I know that you also comment on Second Amendment issues as well, and I want to get your thoughts on a paper that came out recently that showed that gun rights cases has skyrocketed since the Supreme Court decided New York State Rifle and Pistol Association versus Brewer in 2022. Just an example, 865 gun rights decisions were handed down in 2023 in the federal courts, up from 121 in 2021. Your thoughts on why this is happening?
Sure, I can provide some insight on what the court may be doing and why they're looking at so many high cases. But Second Amendment issues are something that the American Legislative Exchange Council is not particularly that well equipped to handle. But I think you can kind of attribute it to the status of the court right now. I mean, President Trump put on 3 very strong conservative justices on the court. Cause lawyering is a very real thing where people are looking for real cases and real people harmed to bring a case before the court and go through appellate litigation to change the law through the judiciary. And I think that people see an opportunity now to really have the federal government recognize their rights to keep and bear weapons, and as they're constitutionally protected, and they want to seize an opportunity to have that better recognized through judicial opinion.
Speaking to Nino Marchese, who is ALEC's Criminal and Civil Justice Task Force Director. Nino, you wrote another very interesting piece just a couple months ago titled "States Can't Afford to Take Away People's Freedom to Drive." Tell our listeners what's that all about, and what were you tackling in that article?
Sure, absolutely. So this article was relating to the practice of suspending people's driver's licenses who fail to pay certain court-imposed fines and fees. And this has been an uptick that we've seen in the last few decades. It's an enforcement mechanism against those who fail to pay certain court fines and fees because they don't know what else to do in that case. And so certain states and lawmakers and courts feel that it's effective and justified in removing their ability to commute and transport themselves and run their lifestyle with an automobile, which I'd say is most regions in the country, especially rural areas. Mm-hmm. And maybe at face value, that makes sense as an enforcement mechanism. But what a lot of our members and legislators have found is that there's really no data to support that. 1, it's effective in accomplishing their goals, and 2, it doesn't actually provide the revenue that states are looking to collect from it. And we found that it actually causes more harm to individuals in the justice system who are indigent but willing to pay, or those that are, out of prison looking to change their lives, they have one job and they're trying to get to work, but now their license has been suspended, and so it complicates the matter more so. And so we put a piece out that shows that it's actually not, by data, actually not in a state's best interest to enact that practice.
Isn't this about the equivalent of a father who maybe got behind on his child support, maybe lost his job or got into a dire financial situation, and the system throws him into jail to punish him? And, you kind of wonder, well, if he's behind on his child support, how's he going to go to work and earn and then pay back child support if he's in jail?
Yeah, that's exactly right. It's a kind of a lose-lose situation. I'd say it's a little worse than that, because the whole context is somebody failing to pay court costs. And, we're not talking about thousands and thousands of dollars. We're not talking attorney fees and legal fees, for pursuing a lawsuit. We're talking maybe hundreds, maybe $1,000, depending on the case. So the pool of people that you're talking about caught up in these circumstances are relatively low-income people, sometimes indigent, often with a minimum wage job. And so to take away their means of commuting, buying groceries, getting to work, and then them being at risk for being potentially arrested for that, for driving without a license. I don't see how that's a prescription to collect more revenue to actually get them to pay those court costs and fines and fees in the first place.
Nino, before we let you go, you talked about hoping that the Supreme Court would go a little further in pushing back against this Chevron Deference doctrine that's been around since 1984, decades and decades. Are there any other cases that you're aware of at this point that are working their way up through the judiciary where the Supreme Court can maybe even take another crack at completely knocking out Chevron once and for all?
Well, in this Loper decision, Loper Bright Enterprises, versus Raimondo, the court did effectively overturn Chevron. I don't think, and just to be clear, I don't think they could have gone any further in their decision, because not only did they overturn the Chevron doctrine, they also stated in the majority opinion that federal courts are no longer allowed to adopt an agency's interpretation. So they didn't just say that they are allowed to at their will. They're no longer mandated. They said they were prohibited from doing so. So I think that's as far as you can go for the respective case that was at hand. As far as, my views and what we see at ALEC is wanting people to go further, maybe in another case, or even Congress or statutorily, they can go further and reining in administrative authority. The whole point here is really going back to the fifth grade, Schoolhouse Rock civics lesson. What is the legislative branch? What is the executive branch? What is the judicial branch? And it's very, very simple. Legislative branch, it's the creative one. Those people make the laws. We elect those people and we vote them out if they do a bad job. Those are the only people who should be making those laws. The executive branch is tasked to enforce them and not make laws. And the judicial branch is on the back end. If there's a problem, there's an issue, a lawsuit, they interpret the law if it's unclear. This whole administrative state, all of the regulatory bodies, it has totally circumvented that fundamental process our founders laid out. And I think this Chevron decision was a great first step in the right direction of waking America up to realize that we need to hold bureaucrats accountable and rein in their authority, because they're not lawmakers that we can just vote out.
Well stated, because we know if we give these agencies an inch, they'll take 10,000 miles. That's for sure. Nino, thank you so much for all the time today. Folks, you can look up everything that Nino's working on at ALEC.org, ALEC, ALEC.org. Nino, thanks so much for the time, the insight, and the analysis. Great speaking with you.
Thank you, Nino.
Thank you for having me, guys.